Yes, Mr. Tristram.
Yes. My Lord, if I could just tidy up on one or 2 points. Firstly, we say that what is distinctive about the sentence to detention during Her Majesty's pleasure is it's the only mandatory indefinite sentence on children. And secondly, if one's distinguishing it from discretionary life sentences, it is because it is mandatory, it's reserved for children, and it has always been interpreted, see Venables and Smith, as carrying with it a duty of continuing review. And then the third point I'd respectfully make is that Parliament did not impose a life sentence. It has preserved the sentence of DHMP, and I know that the court has that well in mind. It's 1908, 1933, 1948, 1965, 2000 in the PCC SA, they retained it, and then again in 2020 in 269. So it's repeatedly reenacted and preserved as a special indeterminate sentence that is both indeterminate and mandatory. And those are reasons why it should be treated as a special case and why it is not anomalous that there should be a tariff in discretionary life cases, but not a reducible tariff in the case of HMP detainees. I did commit to paper just a summary of our 3 points on Article 14, Article 5 and Article 7, which the courts, I can hand it up if you like, but I could just read it out if you want me to.
Well, if you're literally reading out a series of propositions, perhaps we can have it, although I have to say usually this court deprecates additional written materials being handed up. But you've shown this already to Mr. Watson, have you?
Oh yeah, he's had my speaking note for months, I don't know, for a week. So I just hear it. This is just the... yes.
So describe this document for us, just so that...
it's just a summary of the alleged violations. Just so... so it's really...
Thank you.
Just what the essence of our case on Article 14.5 and Article 7. As to Article 14, we respectfully submit it's arbitrary and discriminatory, the provisions of...
So can I just check? Article 14, is the application of Article 14 based on a submission that we're here operating in an area within the ambit of Article 5? So is it
yes.
Article... So
yes, my Lord.
That's Article 14 read with Article 5, is that right?
Yeah, my Lord, absolutely, yes.
Yes, thank you.
And so we say it violates Article 14.
So arbitrary. One should really be dealing with Article 5 first of all, then, shouldn't one?
Well, my Lord, if the court would bear with me, because the Article 14 was the one which is perhaps the most detailed one. It's arbitrary and discriminatory by denying a review only to those who commit their offences under 18 but are sentenced after they attain the age of 18. That's despite the fact that they are subject to the very same sentence as those who are sentenced under the age of 18, a sentence that carries with it a rationale that calls for a review. And that's the divisional court at 47 and 52. The retrospective removal of the review previously enjoyed is unjustified and disproportionate. Firstly, it ignores the reality that HMP detainees such as the appellant continue to mature after their 18th birthday, and secondly, it only minimally, selectively and arbitrarily reduces any distress to victims, and for that reason we say it's disproportionate. We do also say that the removal of the review results in arbitrary detention contrary to Article 5, and my Lords, perhaps I can, my Lords and my Lady, perhaps I can deal with that when I get to Article 5, but in essence what we say is that the review is an intrinsic part of the sentence and a central feature of its rationale, and a prisoner denied a review ceases to be detained in accordance with the purpose and objectives of the sentence, and we've given the references to our case. Furthermore, the removal was not foreseeable at the time of the sentence of this appellant, and certainly we say was contrary to the rationale of his sentence. And then
I mean, the usual position in public law is that policies can be changed from time to time.
Yes.
So why couldn't it be said that it is foreseeable that a policy might be changed? It doesn't set out a legal right or anything like that. It's in the essence of it being a policy that it can be changed.
Well, because the right to a the right to a review, I'm just going to call it that, the right to a review, does not flow solely.
I'm so sorry.
That's
what I think I'm putting to you, that it's not a right, it's something that comes out of a policy that can be changed.
Well, the policy it's because it's only, my lord, because the policy derives from the interpretation of the sentence that we say it's underpinned by the rationale of the sentence.
All right, thank you.
And therefore it has the quality of a right at law.
Well, I can understand that in relation to the initial sentence, the initial detention at His Majesty's pleasure, as introduced in the 1908 legislation, because it is detention at pleasure. And therefore the Secretary of State has to determine what is His Majesty's pleasure. That means the Secretary of State has an obligation to review that at regular intervals. And but there has been a progression in the sentence. This sentence is now a world apart from that. This is a sentence with a minimum term and with parole board involvement. And so there's no obligation, in the sense that there was an obligation to start with for the Secretary of State to keep under review, and a right in the individual for the Secretary of State to perform that exercise. But I have difficulty in seeing how there is an obligation now to keep it under review, and how there is a right to it, as opposed to a matter of policy, which, as my Lord says, can be changed.
Well, my Lord, it really is only if one accepts, it's really Lord Bingham at 11 at page 11F. Sorry, yes, it's paragraph 11F at page 1254F. If in fact the rationale, the inherent nature of the sentence leads to it rather than the identity of the authority setting the minimum term. And he does say the majority would have upheld a requirement of continuing review even if the minimum term had been set judicially. So that is that last sentence, even if the minimum term had been set judicially, they would have upheld a requirement of continuing review, because it's an intrinsic feature of the sentence. That is our respectful response. But my Lord, that's why we say it's arbitrary. But we also say that it would not be foreseeable that there would be a change that would be inconsistent with the rationale of the sentence. And then thirdly, an alternative, the Secretary of State himself asserts that the sentence has been altered or redefined by the statutory removal of all possibility of reviews for those covered by section 27A11. The language of redefinition comes in there at page 349 in their response to the initial action, but was used on a number of occasions that it's been redefined. But such later alteration of the sentence long after it was imposed involves the retrospective harshening of the penalty by the removal of an essential element of the penalty, namely the reducibility of the minimum term. And we respectfully submit that that removal violates Article 7 for those sentenced on the clear understanding that there would be a procedure for review and reduction of the minimum term. Well, I suppose it be not on the clear, but with the clear understanding would probably be a fairer way of putting it. Again, this removal, we say, was not foreseeable at the time that the penalty was imposed on the appellant. My Lord, my Lady, that's a summary. If I can take you then to Article 14, the point that we make in relation to that.
So can I just check, you're now moving to develop each of these submissions in turn?
Absolutely, yes.
Yeah.
So that's in essence our case on the 3 points. And the court will see that there's also, as it were, leitmotif of retrospectivity in relation to all of them. And if I'd taken the court to the justifications that were put forward, the lesser maturation after 18 in the white paper, and then to the less distress to the victim's family, which the Court of Appeal at paragraph 142 saw as the essential feature of the justification. So that's at paragraph 142 of the Court of Appeal's judgment, page 167. Where they say the aim of the legislation was to reduce the distress of victims' families by reducing the opportunities for offenders to apply for reviews of the minimum term fixed by the court to reflect the seriousness of the offence. The legislation did so by providing that those who were 18 when sentenced and who began their sentence as adults would not be eligible to apply for a review.
Just on that,
Yes.
as I understand it, the policy is that you can apply for a first review at the halfway point of the minimum term, but if you're unsuccessful then, you can repeat your applications every 2 years. Is that right?
The policy now, or the policy that was, the old policy?
Give me the answer to both.
Oh, okay, yes. So my Lord, the former position was, at the halfway point, you could apply.
Yes.
And if you got a review, you could then, my Lord is absolutely right, renew it, and that's set out in the white paper. What the white paper said was particularly disturbing and upsetting for the victims' families was repeated reviews, and so they proposed the removal of those. And then, as your Lordships and my ladies saw, option B comes in at a later stage, which is let's remove them altogether from those over 18.
Right.
And
but I just want to check. So in fact, the way the old policy worked, there was scope for there to be successive reviews. It wasn't ever just one review.
Absolutely.
So when we're talking about distress to the victims, it is relevant to have in mind that you could have successive reviews over a series of years.
My Lord, absolutely. And
right.
we say that, therefore, much of the... Because this is the only reasoning we've got, because there's no reasoning, obviously, that we can look at in Parliament, but the only reasoning we've got is the white paper. And the white paper is emphasising the problem for families of repeated, continuing, subsequent reviews, I think, the 6...
Sorry, when you say that's the only reasoning we've got, is there nothing additional in Mr Webster's witness statement? I thought he exhibited the submission to the Minister.
Yeah, yes.
And that has reasoning set out in it as well.
Well, not much reasoning in relation to why, other than just let's remove option B is remove it altogether.
All right, but at all events, you're not suggesting we can't look at Mr Webster's witness statement and the submission to the Minister.
No, of course, no, of
all
course.
Right.
I accept that. I mean, that's the sort of Lord Wilson's judgment, saying you can look at background materials to look at the underlying purpose of the legislation. And so the white paper certainly comes up in that category, and we would accept.
Right, but I've understood your answers just now to accept that the witness statement and the submission to the Minister come into that category as well.
Yes, my Lord. Yes, I accept.
All right,
that.
so I just wanted to make sure that we understood.
Then, well, I know that the court has, when we've set it out at paragraph 40 of the case, that it was conceded during litigation that the impugned provisions amount to an interference within the ambit of Article 5, that the appropriate comparator for Article 14 purposes is another child offender subject to the same sentence, whose sentencing hearing fell prior to their 18th birthday, and thirdly, that the differential treatment on the basis of age at the time of sentencing is on the grounds of a status that engages Article 14. So the only issue that remains is whether the impugned legislation has an objective and reasonable justification. We obviously adopt the reasoning of the Divisional Court. Can I just give you the references? That their point at paragraph 47 that the sentence remains the same sentence, the sentence determined by age at the time of the offence, that at paragraph 48, a bright line by reference to age at the time of sentence was not sustainable. At paragraphs 49 and 50, that accelerated development is present also for those over the ages of 18, and they develop that at 49, 50 and 51. And an important point at paragraph 54, you cannot start as if there was no history. As it were, you can't just say, this is Parliament giving a right of review without any background to it. Is it appropriate to draw the distinction at that point? You have to look at the removal of a right that was being enjoyed before. My Lords, my Lady, we also make the point that even if the right to review was not mandated by Article 5, the European Court in Cliff recognises that, and this is the paragraph 60 point of Cliff, and my Lord Sales adverted to it. The general purpose of Article 40.
What page number is it, sorry?
It's paragraph 60 of Cliff, my Lord. If you just give me 1 minute. Yes. Paragraph 60 of Cliff, page 1600. It says it should be recalled that in this regards, the general purpose of Article 14 is to ensure that where a state provides for rights falling within the ambit of the Convention, which go beyond the minimum guarantees set out therein, those supplementary rights are applied fairly and consistently to all those within its jurisdiction, unless a difference of treatment is objectively justified. So it may be...
Right, that's the falls within the ambit of a
yes.
provision.
Yes, but it's also that you don't answer the question by saying, well, there was no right to a review. It was merely a matter of mercy, which has now been put.
Sorry, where do you get that from?
Well, because it says rights is to ensure that where a state provides for rights falling within the ambit of the Convention, which goes so the new right that is created beyond the minimum guarantees set out therein, that's to say the right to a review for all those subject to HMP detention, except if you exclude those who were sentenced after 18, we say that you're not fairly and consistently dealing with those supplementary rights.
Right, but that's where it comes back to objective justification.
Yeah. Oh, yes, my Lord. Yes, I accept there has to be an objective justification, but we say that there is no. But I'm just saying that it is no answer to our complaint that even if it were the case that you weren't entitled to it before 2022. In other words, that it came as a matter of policy which was susceptible to change. If Parliament decides we are going to address the problem of reviews for HMP detainees, and we're going to give the right to a review to all those sentenced under 18, but deny it to those sentenced after 18, that has to be objectively justified, my Lord, and we say it isn't.
Right, but I thought that the Secretary of State accepts that it has to be objectively justified.
Yes,
right.
my Lord.
Okay, well, in which case we're all on the same page, aren't we? I'm not quite sure why we need to take that time with paragraph.
I think the right point is a different point, isn't it? It's to do with whether this is about the sentence or about the execution or enforcement of the sentence. I think that's where the policy points were going. They weren't going to this point about about Article 14. I don't think.
I'm just yes. I also am struggling to see why you've taken us to paragraph 60. But
well, if I'm not assisting, I'll move on.
I don't want to stop you from doing it. If you have a point that you want to make on it,
it's just that the Court of Appeal took considerable amount of space establishing that there was in fact no right, it was all a matter of mercy. And we say, well, so what? If you decide that you're going to have a new statutory framework for all those sentenced to HMP detention, and you say all those sentenced before 18 will have this right, and all those sentenced after 18 won't, there's no objective justification once you factor in that they're all subject to the same sentence based on the date of the offence. That's our simple.
I still don't understand why you're referring to paragraph 60.
Well,
because, just point out why I'm wrong. What you're challenging is the compatibility of Section 27A, and that does differentiate, and therefore you have to objectively justify. It's totally irrelevant as to what the previous policy was. You're challenging Section 27A.
Well, except when, my Lord, if you are retrospectively altering...
Yes, well, that's a different point.
Then that goes to the objective justification. I mean, for example, one of the things you have to look at when you're dealing with objective justification is whether a lesser alternative was available. And if there was a lesser alternative which preserved the right that those HMP detainees sentenced after 18 had in the past, then that is, in our respectful submission,
what is... Sorry, objective justification, you look at whether it's retrospective. Well, if you alter sentencing principles in relation to terrorist offences, that is retrospective. And, why does retrospective nature come in to objective justification?
Well, because, my Lord, one of the questions that has to be asked is, could the objective be achieved by a less...
That's a different question. Is there any authority at all for saying that objective justification must take into account whether it's retrospective?
Well, my Lord, all I can say is that the case of Akbar, which is cited as against us on this point about it's irrelevant.
Right.
Just simply this, that there is an instinctive principle which underlies the reason why we have transitional provisions in parliamentary legislation. There is an instinctive and long justified principle against making changes retrospective so that they affect people who had enjoyed a particular legitimate expectation without a real need for that.
But that is where the question of whether it's a right or just something expected under a policy comes in. Because if it was part of the sentence, then you'd be on very strong grounds.
Yes.
But if it's part of execution and enforcement, it's
well, my lady, you know where my submission on that is. It is, and that may go to Article 7. And there, obviously, we have my Lord Stephen's judgment in Morgan, which I hope to say supports us, but because it draws a distinction between enforcement and amending the nature of the sentence, and we say this effectively is amending the nature of the sentence. In fact, it was justified on that basis in the
right. But I'm now on to leapt forward to the last of your submissions. Perhaps we should focus on Article 14, so we get a complete submission on that, and then we can move on.
I submit, my lords and my lady, that when it comes to proportionality, there is a clearly disproportionate impact in removing long after their time of sentence the right and certainly even the legitimate expectation, of a minimum term review retrospectively, simply because they do not come to be sentenced until they are after the age of 18, or they did not come to be sentenced until after the age of 18. If and to the extent that there is some reduction in distress to victims by removing all possibility of review from this limited category of detainees, the impact of the removal is grossly disproportionate. And then we say that's particularly so in the case of those like the appellant, who were sentenced at a time when there was at least a legitimate expectation of a review, even though they were actually sentenced after they attained the age of 18. So that is my submission, that it goes to the is this disproportionate issue.
What do you say about the margin of appreciation?
My lady, I say even taking full account of that, which is what the divisional court said, we give full account of that. It is.
How are you giving account to it, though?
Well, my lady, I'm giving account to it in this way, that if this is about less restrictive alternatives, which is a relevant thing. If Parliament, you give deference to Parliament saying we must do something to reduce the distress of victims, and that would certainly legitimate removing the repeated reviews for the reasons given in the White Paper. Instead, they have firstly removed all reviews from those sentenced over 18, not just repeated reviews. And secondly, they've removed those reviews despite the fact that they had a legitimate expectation in the case of this detainee for many years that they would have a review. And the same underlying sentence that gave rise to that legitimate expectation. And so we say that makes it all the more disproportionate. Also, there's a judgment of my Lord Hamlin in the case of Achille Charles, which we've referred to, where the failure of the legislature to consider less restrictive alternatives was taken into account. And that's the case of Achille Charles is at tab 81. And that was the removal of the right for bail for all those charged with murder in Trinidad. But it starts at page 1965. But in going through the exercise of testing the proportionality of that removal, at page 1987, my Lord Hamlin looks at the question of whether a less intrusive measure could have been used, and that one sees that in fact, generally speaking, the judges had refused bail in murder cases, so there was no need for the legislation, the less restrictive alternative. And one sees that at paragraph 85, page 1991, the board has given careful consideration to the strong public interest in the objectives of the bail provision and the great weight to be given to the judgment of Parliament. Bearing in mind that less intrusive measures could have been used, the board nevertheless considers that in all the circumstances of the present case, the interest of the community, as expressed by the will of Parliament, is outweighed by the very severe consequences of the imposition of a blanket prohibition of bail, and a fair balance has not been struck. And that refers back to paragraph 63 following about something less restrictive could have been done. And the board accordingly concludes the bail provision was disproportionate. So that's just one example, but we respectfully submit.
But I mean, if the objective of the legislation is to minimise the distress to victims' families, what is the less intrusive alternative?
Well, the less intrusive alternative is to, one, do it prospectively, that's to say for the future.
Sorry, I don't understand.
Well, my Lord,
because that will still involve reviews causing distress to victims' families, won't it?
Yes, but you would...
Well, you say yes. Yeah, I thought you were identifying for us a less intrusive alternative that would secure that public policy objective. But when you say yes, you're accepting that it wouldn't secure that public policy objective.
Well, my Lord, what it would do is it would advance the policy for the future of removing distress prospectively. That's to say, from now on, it will be known that you will not have a review if you're sentenced after 8.
But it'll achieve that result prospectively.
Yes.
In relation to the current legislation, because it means that persons who were sentenced to Her Majesty's pleasure when they were 18 or over will not have the reviews that would cause distress to victims' families.
Yes, so you
So,
can...
it might be said it's perfectly aligned with the public policy objective to that extent.
Well, my lord, my submission is that it is a question of balance and proportionality.
I appreciate that, but I'm so sorry to pick you up on this.
No, quite.
You said that this was a case where there were less restrictive alternatives, and that was the point of going to Achille Charles. And I'm asking you, what are the less restrictive alternatives, given that the public policy objective is to minimise distress to victims' families?
Well, it's to reduce distress, yes, and you would reduce distress because in the future no one would over 18 would, but you wouldn't remove all. I accept you wouldn't remove all possibility of distress, but you would balance the fact that your objective is to reduce distress, and you're going to achieve that by your prospective change. But those in the pipeline who had a legitimate expectation that they would have a review would continue to have the review, and it would be statutorily underlined, and therefore it would be
that sounds like a sort of a submission which accepts that there would not be less restrictive means, but nonetheless it would still be a disproportionate interference with the rights under Article 14 of your client. That's what you just said sounds like to me. Well, but please explain if I've misunderstood, okay. Because you did start off by saying you were relying on the less restrictive alternatives bit of the proportionality rubric. But if you put it in the way that you put it just now, you seem to be accepting, well, there were no less restrictive means available, but if you weigh up the public policy objective that was sought to be achieved against the impact on the individual, a fair balance has not been achieved. That's a different submission, obviously.
Well, my lord, if there's if you're my lord, it may not matter, but
well, it matters to us in terms of analysing the case. That's why.
I appreciate it. My lord, we can see it in a number of ways. We can see, for example, there was the proposal put that there should at least be a discount where it wouldn't apply where delay had caused there to be delay in the legal process, had caused the person to be sentenced after they achieved the ages of 18.
But I mean, presumably the reason those options weren't chosen was because they wouldn't achieve the desired objective of protecting victims' families from further distress.
Or just because they wanted to have a very clear new approach, but that doesn't. Right. I mean, supposing the policy had been, and my lord, let me just put it. Supposing the policy had been, if we'll take the date at which you were charged, for example, the date at which you were charged as the relevant date, and therefore, if it's to do with delays in the court system, then you will still have your review. I suppose what I'm respectfully submitting is that there would be no legitimate basis on which a victim's family can say, you should not expose me to that distress, because you could only reasonably accept that if the additional distress was caused by a delay which was no fault of the offender, it wouldn't be a legitimate basis on which to advance that objective. It would be wrong and contrary to due process. It would be arbitrary.
Yes, thank you.
And my lord, that's a small example.
It isn't, though, the delay that causes the distress, is it? I mean, the distress is caused by the victims' families having again, whether shortly or long after the original trial and sentencing, to consider and possibly be interviewed about or asked to respond to consultation about an application for a review.
Well,
I mean, it's difficult to see how, whether that happens 1 year, 2 years, 5 years or 10 years after the event is going to be critical to the amount of distress it causes.
Well, my lord, it may be that, as my lord Sells has put to me, this is really about proportionality and whether it's achieves a fair balance. But my respectful submission would be, if you look at the criminal justice system, it inevitably involves, and now at the stage of parole, consultation with the family or notification to the family. But nobody suggests, well, let's get rid of the parole system because it causes distress to the family. If something is necessary, ex debito justitiae, but as a matter of fairness and due process, you can't then say, well, we'll get rid of that right because it's upsetting. You have to say, is it legitimate, does it strike a fair balance, in my Lord's words, to say that, well, the distress of the family will take precedence over legitimate expectation founded on years of practice and on the work that the offender had put towards winning a reduction. And that's, as it were, something that runs through the whole criminal justice system, that we never say, well, though this right is essential for due process, or we'll sacrifice it because it's upsetting when the right is enjoyed. We never say...
But I mean, it hasn't been fully sacrificed. So even in relation to offenders in the category of your client, it's not that there will never ever be scope for review by the probation authorities. It's just that those will be pushed back until after the end of the minimum period. So,
yes.
So I mean, it might be said that the legislation is aiming very specifically to strike a fair balance between the interests of the victims' families and the interests of the detainee by balancing the degree to which the detainee can seek reviews and pushing it back beyond the minimum period. That is a balancing exercise in and of itself, isn't it?
Well, my Lord, I suppose that there is a conceptual difference, because at the parole stage, you have a recognised right under Article 5.4.
Right.
You've got to have a review.
Yeah, quite so. So I think you're making the point that I was putting to you, that it's not that they don't have any reviews at all, it's just that the scope for reviews has been reduced. It's not as extensive as before, but there still is scope for reviews. And it might be said that that is Parliament itself seeking to strike a fair balance between the interests of the victims' families and the interests of the detainee.
Well, my Lord, I would say that there is a conceptual distinction, in the sense that no one could even propose doing away with parole board reviews, because you have to test the question, is this person dangerous? And at that stage, the family will obviously be notified. This person is applying for their release, as is their right. We would submit that in this case, those who have acquired a legitimate expectation at the least under the existing system, one could simply say, well, this is the right, that this is the expectation they have. For the future, we're going to rule it out. But not in respect of those who have acquired this legitimate expectation. And my Lord, we say, the other point we respectfully make is, you can't achieve that kind of finality whereby there is no distress as long as you have a system of criminal justice that involves looking again at the offender to see whether the time has come for them to be released.
Right, but I don't think the objective was to remove all distress at any point in time to the family. That it was just to reduce the amount of distress. I mean, is that not a legitimate public policy objective in itself, to reduce distress,
well,
not to seek to remove it for all purposes and at all times?
Well, my Lord, I think, can I just put it, sorry, the answer is yes, it is a legitimate, I accept.
Yes,
I accept.
right. Thank you.
But what I'm submitting is that though it's a legitimate objective, one can look at a number of factors. One of those factors is the limited input I mean, in other words, it's not something where they have to have an input. It's an option. You're notified, and you can if you. And that was the point made by the divisional court, that really this is about progress in custody, in which the family have limited input. So it's not necessary that they have that input, though of course we accept that they have to be notified that this is happening. And that is important in
I wonder if that's so, because the exceptional progress must be balanced against the other aspects of sentencing, namely punishment and retribution. What is exceptional depends upon the nature of the crime that was committed. There's a balance between the two. That's the reason why it's got to be exceptional, because by very nature of of murder, it requires something exceptional.
Yes.
And so the family would have a legitimate view about how awful the crime was.
Yes, my
So
Lord.
there is a balance to be carried out. And they have got, I mean, you say progress in custody is something out with the knowledge of the family. Well, that may be so. But they got an interest in making submissions about how awful the crime was.
Yes. Well, my Lord, all I can say is if you look at the 2018 statement, I drew attention to it. It said it's not necessary for them to comment on progress, and they will have already commented on the enormity of the crime at the time of sentence. I mean, that's the Home Office's own policy statement, saying that they have, I think they say they have limited input on progress, and they will have already made their views clear. I mean, if in the end it comes down to...
But sorry, the policy wasn't that they'd be shut out of the process, was it?
No, my Lord. If one looks at the 2000, I accept that, my Lord. It's if one looks at the 2018, is it page 586? 2018 statement, 581. Sorry, it's above explanation of exceptional progress in prison. The views of the victim's family may be sought.
Sorry, what was it?
Page 581, my Lord.
Page 581.
Yes. So the views of the victim's family may be sought, but can only be relevant insofar as they've inform an assessment of the seriousness of the offence. These factors will normally have been taken into account at the time of sentence. So, I mean, well, my Lord, I'm just saying that...
I mean,
this is
if I was a family member and another family member had been killed by someone, I would certainly want to express views in relation to a process like this. And as I understand it, I would be permitted to do so under this policy. Is that right?
Well, it says the views of the victim's family may be sought, but can only be relevant insofar. I mean, my Lord, I think the position is this: the family are notified this person has a medical occupation, and what they're saying is that the very fact of notification causes distress. I think if we look at the white paper, my Lord, white paper on this issue.
Yeah. 554, I think, was the white paper.
It's at page 554, my Lord, yes. But to determine whether the terror should be reduced, the child can continue to, and then, yes, and then one sees families are contacted every time an offender applies for review and are given the opportunity.
Oh, so they are given the opportunity.
Yes, to provide a new victim personal statement, a process which in many cases, yes, so they're given that opportunity.
Right, sorry, that's what I thought was the position, but then you seem to be...
Well, it's just that they're saying that they may be given the opportunity, but that there's limited relevance to what they're saying. That's what the Home Office's own policy says. Because difficult to see. I take my Lord Stephen's point, which is that if you're balancing progress against the enormity of the crime, they may wish to re-emphasise the enormity of the crime. But that's the point made by the Home Office's own document is they will have already done that.
In a sense, I mean, notification is inevitable.
Yes.
Otherwise, it appears to the victims' families to being done behind their back.
Yes, yes.
And notification of itself, even if they're not asked to comment, is likely to cause distress in the sense that it throws back into the melting pot an uncertainty as to what the penal consequences of the murderous assault on their family member are going to be.
Yes, yes, my lord.
Most victims, one suspects, get some measure of comfort from finality.
Well, yeah, yes, my lord. All I can say is...
I know you say, well, it comes back when you get to the parole board, but
yes. Yeah,
that's only at the end of the tariff period.
It's a reduction. It's a. I have to accept, my lord and my lady, that there is some reduction. There's some inevitable reduction as a result of nothing has to be notified because nothing's happening.
Yeah.
I have to accept that. But when one comes to proportionality, if it's necessary to give effect to the rationale of the sentence, then we respectfully submit that it's a fair balance would maintain that right. But moreover, if you think of it this way, the family will have been told at the time of sentence there is a right of review. He can apply for a reduction of the sentence at the halfway point.
What makes you think they will have been told that?
Well, because if you're telling people about...
the judge doesn't say that.
No, he doesn't. But I mean, if
you're assuming that they're advised by someone.
Yeah, yes. I mean, it was well known that I mean, it's set out by Lord Justice Davis. This was a well-known process which had resulted in reduction in many cases.
We need to disentangle retrospectivity, don't we, from the merits or justification of the reform itself. In this case, you may well say that the victims' families will have been told that there's a prospect of a review.
Yes.
But looking at the proposed reform of itself and the complete removal of the prospect of review from someone who is sentenced only after achieving 18, those cases will not include any notification at all to the victims' families. They will be let off having to worry about they will be let off altogether from having to worry about the prospect that the tariff is going to be shortened.
Yes, and that's why my respectful submission is if one's dealing with proportionality, a prospective removal, so that everybody knows where they stand for the future, would be less disproportionate, then it would obviously be a different kettle of fish than saying, well, because it would be known that it would be accessible that there is such a review in 2015 and accessible both to the prisoner and to the family. That was the system.
And you say it would be less disproportionate.
Yes.
Either there are going to be reviews in a particular case, or there aren't. So I'm not sure that.
Well, my lords, we're testing the legislation. One of the things that legislation could have done and didn't do is to say, for those sentenced from now on, there will be no review at all. But those who...
And that's what I understood you to be saying. All I was saying is, well, if the legislation goes down that route, that is already to concede in the case of the families that happen to be associated with offenders in the pre-existing category, that they simply must suffer the distress associated with reviews.
Yes, well, my lord, that...
So you seem to be making a point looking at the entire population of cases that might be covered by this reform and saying, well, if you look at the entire population, some people will be affected, others not. It's less disproportionate overall. And I'm putting to you that actually, in this area, one would expect to test proportionality by how it affects the individuals in particular cases, i.e. the victim, families of the victim in the particular case and the offender in the particular case. And on your suggested solution in terms of meeting a problem of disproportionality, it's a solution that completely subordinates the interests of the victims' families in that class of case, where you say the protection of the detainee should take priority.
Well, my lord, I'm just saying that the legitimate interest would be lesser in a case where it had already been the legitimate expectation of the person.
And that's what I'm seeking to test. Why would it be less
Because,
in that sort of case?
Because it would have been understood that that was what the system was until it was changed. And so why? So if you say
forgive me, that doesn't stop it being very distressing when it happens. You might understand. I mean, query whether you do, as my lady said, it's by no means obvious that the families would be told. But suppose they are told. It doesn't make it any less distressing when it actually happens.
No, but it makes it more unfair to the prisoner. If you're doing a fair balance.
I see. All right.
My lord, if you're doing a fair balance, you have to balance in this is very unfair to the prisoner. And families do understand concepts of fairness. I mean, you know, right. I accept that this was the system. I'm glad to know that the system is changed for the future. I accept that this was what this person would have been told and would have been expecting. That's not a concept in our respectful submission that a family wouldn't understand, and that the government shouldn't have, and Parliament shouldn't have factored in. And that's why typically there are transitional provisions when you're making a big change, because there has to be some recognition that those who've worked within or lived within a different system have expectations that ought to be respected. My lord, that's the way I put it.
Yes.
So yeah.
Do you place any reliance on this possibility that a judge who sentenced a defendant at a time when the law was, and the judge therefore assumed that he would get a half-time review, might impose a longer tariff than a judge similarly placed who understood that the review would not be subject to, that the tariff would not be subject to a half-time review?
I think it must be possible that would be factored in, my lord.
And if so, into what, as it were, box does that perception fall?
This is, as my Lord Sales put to me, this is about fair balance.
Yes.
The fair balance is different in our respectful submission in the case of those who have been sentenced under a particular regime, and fair balance both because that's what the judge would, after Smith, would have expected, and even after Smith, the policy remained the policy for all of them, both those sentenced before the 2000 Act and those sentenced after the 2000 Act. We know that remained the policy up until 2022.
I may have misunderstood my Lord's question to you, but are you accepting that a judge sentencing somebody would take into account the fact that there's a possibility of a halfway point review and therefore impose a longer sentence or longer tariff on the offender in order to cater for that? Is that really what you're accepting? That sounds to me to be public law irrational.
I don't think you could impose a longer one.
I think that's what my Lord...
Sorry, you're going to give a lesser discount, though, I suppose, on the basis...
it's the same thing, isn't it? It's just put another way around.
Lord Hope, in Venables, suggested that the sentencing principle should be that a judge in sentencing should impose a lesser tariff so that it gets back to the parole board as quickly as possible. So Lord Hope was proposing a sentencing regime that took into account potentially. Let's just find that.
Yes.
I think that's a different point, though. I think that's to do with the fact that you're sentencing a child, or at least somebody who's young and potentially maturing or vulnerable. To take into account merely the existence of a halfway point review.
Well, it's page 1514, letter E. And
1514.
1514, letter E. He was dealing with the anomaly between discretionary life sentences and a mandatory sentence of detention. and Willie says, well, the welfare principle will take into account the need for flexibility in the treatment of the child, and will set the minimum tariff so as to ensure that the earliest possible moment matter comes under consideration of the parole board.
Yeah.
Yes, so, as my lord putting that would be how you'd have to approach the sentence initially.
Yes.
Yes, yes.
I think that's a different point.
But the trouble...
Well, yeah, I mean, it seems to me that cuts against the point that my Lord Briggs was putting to you, which you seemed at some point to be flirting with accepting, because Lord Hope is saying you take account of the age of the child when setting the minimum term. Because, of course, at the end of the minimum term, that's when you get the right to go to the parole board. He's not suggesting that you factor in, well, you might get a halfway review. And indeed, his way of putting it has a tendency against that being a factor that you could legitimately take into account. But I think we just need to know your submission on this at this stage.
I wasn't putting I was simply seeking to say find out whether it's part of your case, and if so, which box it falls in. I don't want to unnecessarily...
My lords, my lady, having heard the comments, I don't think that
you're not going to go down
as an avenue I should go down. But I do submit that the expectation that there would be a review at the time reduces the sense of outrage or...
So let me understand absolutely clearly. You're accepting that the minimum term in this case was set appropriately?
Yes.
Taking into account every single relevant factor?
Yes, my lord.
Okay.
Now, Mr. Fitzgerald, we're still on your first submission,
okay, well,
and
my lord,
I'm conscious that you've got quite a lot to get through.
Yes, my lord. So
before we leave whatever you wanted to say about Article 14, my lady a little while ago asked you whether you had any submissions to make about the ambit of the margin of appreciation.
Yes.
And I just want to check whether there was anything further you wanted to say about that.
You mean apropos of the legislative, respect for the legislature?
All those sorts of things. I mean, there's a whole series of points that feed into either widening or reducing the margin of appreciation.
Yes.
I mean, for instance, another factor that tends to widen the margin of appreciation is if the legislature has balanced competing rights and interests, as it might be said the legislature has sought to do here.
My lord, yes. The points I would respectfully make are, we've set out a number of factors about the impact which are relevant to the, and those are in our case at paras 46 to 57, the impact, and the we say that it's relevant, there is a risk of arbitrariness here, and that was accepted in Cliff to be a relevant factor. And we submit also that in many cases the timing of a sentencing hearing is wholly outside the control of the young person concerned. Then we've admitted also that
it may be my fault. I'm just scanning those paragraphs. They don't seem to be about the ambit of the margin of appreciation, but am I
no, well, except for the legislative scheme operating retrospectively, we say that is a factor to be borne into mind.
Right.
But my lord, in relation to those, what we say is it is the Court of Appeal treated the fact that Parliament had considered the matter and reached its own view as all but determinative. We can see that at paragraphs 124 to 125, paragraphs 132, and paragraphs 142 of the judgment. Those are at pages 162, 163, and 167. It is right that the terms of the legislation itself removed any opportunity for those sentenced to HMP detention after 18 to exercise the right to seek a review of the minimum term. It's also right that an amendment to substitute the age of 26 for the age of 18 was voted on and rejected. My lords, you have that at page, in the bundle at pages 664. So we accept that. One can see that the amendment is at page 661 at the top. The amendment for minimum, so it was really just substituting 26 for 21. And one can see at the bottom of page 664 that Alex Cunningham presses the amendment, and so he says, for that reason, I will push the amendment to a division, and so the amendment's put. So to that extent, we accept that this is something that has been considered. If we look at the case of SC, then what Lord Reid says there is that it may be of relevance in the court's assessment of justification and proportionality.
Sorry, could you give us the page reference?
It's page 1239, my lord. 1239.
Thank you.
So he says, there's tab 56, sorry, you didn't, but he says it may be of relevance.
So, sorry, which paragraph did you say?
It's paragraphs 182 and 183, where he's dealing with the question of Parliament.
Right.
So, 1239.
Yes.
My lord, you can see. Yes. However, he says at top, if it can be inferred that Parliament formed a judgment that legislation was appropriate notwithstanding its potential impact, then that may be a relevant factor in the court's assessment because of the respect which the court will accord to the view of the legislature. So it's not as strong as the suggestion was in the Court of Appeal. It may be of relevance.
But I think you need to look further back, paragraph 181.
Yes.
It's where they refer to animal defenders and
yes.
I have to say also, I mean, one reason for drawing the party's attention to the JR 123 case is there's a section at paragraphs 48 and following about the factors that widen and reduce the margin of appreciation, and a number of Grand Chamber Strasbourg authorities which put particular weight upon consideration in Parliament are cited there.
Yes, of course.
So it does tend in Strasbourg to be treated as a very significant factor that the legislature has itself actively reviewed a range of options and picked one.
Well, my lord, I accept that, but of course Strasbourg then permits a great deal of scrutiny of what actually was decided and what was considered by Parliament. It's right, if one looks at paragraph 183, and that's at page 1239, Lord Reid says, trawling through debates should therefore not be necessary and is unlikely to be appropriate, but a high-level review of whether a topic was raised, whether it should suffice. Now,
right. But you yourself have taken us to the introduction of an amendment in Parliament which was defeated.
Yes. Well, that seems to be a high...
So your own submission is accepting that we can look at least at that.
Oh, my lord, yes, that's precisely why I'm looking at it.
Yes, all right.
I'm saying that it's a high level... but I'm saying there's certain other things that you can get from a high-level review.
All right.
But we're not trawling through the debates. We're saying, first of all, you just have to look at those 4 pages, and there's not one mention of retrospectivity. There is a recognition that there will be no reviews for those who sentenced over 18, but no recognition of the problem of what about those in the pipeline. And that's on a high-level review.
Right.
Is there one mention of the word retrospectivity? Answer. No.
Aren't you there falling foul of what Lord Reid says at paragraph 184? The courts must not treat the absence or poverty of debate in Parliament as a reason supporting a finding of incompatibility, which seems to be what you're just exactly what you were seeking to do just then.
Well, no, it's not that there's no debate. It's just if it's legitimate to say this amendment was put and defeated, it must be legitimate to say no amendment and no consideration was raised, and no issue was raised as to retrospectivity. That's a high level...
It was inherent in the provision that it was going to have some retrospective effect.
Not
because there were people already in the pipeline.
Well, but that's precisely the point. You could read it as you could read it equally as from now on, or I mean, it's just not a. What's actually said in the debates is simply that those who are over 18 will not have a review.
Yes, those who were sentenced.
Yes, over 18 will not have a review, but
that
it doesn't
will
say
inevitably affect people who were sentenced at 18.
Well,
of which that there will be some. In the nature of things, there will be some.
My lords and my lady, if not, it's not trawling through the debates, but consistent with the high-level thing to make that point, I make that point, and I say that there isn't evidence that that was even raised as an issue or considered. And my lords, we have set out, and I accept that this may well trespass over the page 664, the Minister saying, the law as we propose to amend it will allow, most likely in almost every case or very many cases, a single review after the age of 18. I know the court has my submission on that. That's pretty confusing as to whether anything is being taken away or isn't. We say, even on a high-level review, there is no clear confrontation of the issue of retrospectivity, and that is significant. But, my lords, my lady, we accept that it may be a relevant factor that Parliament formed a judgment.
But so, just to be very clear, do you accept that this is a manifestly without reasonable foundation case, or do you?
No, my lady, no. because in SC, what Lord.
Well, just tell me what you do say is the margin of appreciation.
I say this is a case of close scrutiny.
And can you just give?
And that's because of SC.
The bullet points for why?
Yes, Melly, I will, because in SC, when Lord Reid is discussing this, he says that one must have a flexible approach.
Yeah.
And standard of review. So it's I think we deal with this in the case, but shall I just put it in these words? Although contracting states enjoy a margin of appreciation, the scope of the margin will vary according to the circumstances.
So are you now reading from the judgment?
That's Clift. Yes.
All right. Which paragraph was that?
That's Clift at paragraph 73.
Page?
At page 1604. And so the scope of the margin will vary according to the circumstance, subject matter and the background. Clift at para 73, page 1604.
Right.
Then Lord Reid says...
Yes, okay. So Lord Reid in SC now, is that right?
Yes, and this I think is in paragraph... It's in our case, paragraph 42, I think. But
which paragraph of SC is that?
It's paragraph 142.
Thank you.
There may be a wide variety of factors that tend to heighten or lower the intensity of the review.
And just excuse me, what page number is that?
It's page 1227, my lord, at paragraph 142. And he further recognised at paragraph 158, at page 1232, that a flexible approach was necessary to the intensity of review depending on the circumstances of the particular case.
But in a sense, these are all statements about what the nature of the exercise is. That's precisely why I've asked you what submissions you want to make about the width or narrowness of the margin of appreciation. So these paragraphs just tell us it varies.
Yes, absolutely. But then if you look at the factors, one of them, the factors that we say are relevant are that the measure amounted to a deprivation of liberty and that the differential treatment here may give rise to arbitrariness.
Sorry. The measure amounts to a deprivation of liberty, but surely it's the sentence that is the basis for any deprivation of liberty.
Okay. It's in the context of deprivation of liberty, and the differential treatment here may give rise to arbitrariness. That's Clift at 62 to 73, page 1601 to 1604. And furthermore, there's the striking element of retrospectivity in a case such as this. So we say that's the reason why there should be a heightened level of scrutiny. And the respondent says at paragraph 108, page 103 of his case, should be a lighter intensity of review of matters concerning penal policy. That's based on 161 of SC at page 1232. But that approach is more applicable, we submit, to matters of prison allocation and the distribution of resources, such as the question of assignment to an open prison considered in the case of ACPAR, where they say at page 1009, at paragraph 73, at the heart of this case is prisoner management and the allocation of scarce resources. We say the same approach cannot be applied to a fundamental issue, such as the retrospective alteration of the nature and effect of a sentence and the denial of access to a right inextricably bound up with the nature of the sentence. In such cases, we submit that the standard of careful review, which was adopted in the case of Cliff at paragraph 62, page 1601, is the appropriate test. So the more exacting test of careful review. And we've listed in the case at paragraphs 46 to 57 all the reasons why we say the impact calls for that careful review that was held to be appropriate in Cliff, where there's a risk of arbitrary detention. And I think your lordships have those points, but they're all set out in the case at paragraphs 46 to 57. And then as to the justifications put forward, I think we've really identified them in the white paper, and we've emphasised that this is really about repeated reviews. My lords, my lady, we do set out at paragraph 62 of the case our submissions on the second justification, that's to say the impact on the victims' families, and we say that the proposal to remove all reviews for those sentenced over 18 put forward in the memo doesn't conduce to certainty. In the end, the reduction of distress to the families was the crucial justification in the Court of Appeal, but the principal concern of the white paper was to reduce repeated reviews, and we respectfully endorse what the Divisional Court said in its judgment at paragraph 57, that's paragraph 57 about the impact of a single review will be modest. And then we say it doesn't necessarily involve the input of the victim's family. Of course, they're entitled to be heard, but it's not one of those things where you say, well, they've got to be heard. And it's not an area, as the court knows, where finality is achievable given other forms of review, which are inevitable in the criminal justice system. And then we've set out in the case at paragraph 67 that if the sentence of DHMP is of a nature that requires and anticipates a review of the provisional minimum term, then that is a requirement of the law flowing from the nature of the sentence. So, of course, the families have got to be notified, but you can't suggest, it wouldn't be appropriate to suggest abolition of that right or even legitimate expectation.
So why do you, sorry, I'm looking at paragraph 57 of the Divisional Court's judgment at page 193 now. Yeah. Why do you say, they say, that at the end of the minimum period, a prisoner will be eligible for parole? It's then that families of victims will have a significant role to play. In comparison, the effect of a single review of the minimum term will be modest. Well, I'm not quite sure that I understand why it would be modest. It's, if the family are going to be making representations in relation to a review of the minimum term, and that's happening earlier rather than later, one would think it would probably be lead to a bigger impact of distress on them, because it may result in the earlier release of the person that has murdered their loved one or whatever, and they're still being involved in the process, making representations, and it's all been dredged up for them.
Well, my lord, what I can say is the involvement of the family in the parole review is now a matter of law. I think there's split.
Yes, yeah, but I think we've established a family is going to be involved in both parole review and minimum term review. So families involved in both these things.
One is a matter of law and the other is a matter of practice.
But we're looking on the impact of the family, which doesn't really depend upon why they're involved. It depends on the fact of them being involved. And in relation to their involvement for a review of the minimum term, that's going to happen earlier in the sentence being served by the person that has killed their loved one. One might think that they would regard that as more distressing because they're going to have to rake over all the coals, and that's going to be very upsetting. And moreover, the outcome of this process may mean that the person that killed their loved one is going to be released earlier rather than later.
Well, I suppose is the word release, because the parole board has the power to order release. The reduction of the tariff doesn't affect release at all. It just means that you're looked at by the parole board earlier. So I suppose that the...
No, but I thought the point of a single review of the minimum term, I thought the point of that was to show I've made exceptional progress in detention. I should therefore be released earlier.
No, it's the purpose of that is I therefore should have my tariff reduced and then have the opportunity to put my case to the parole board.
Right, leading to earlier release.
Well, my lord, one, that gives the family notice that the person may be released earlier. I accept that. But that may actually conduce to clarity.
Right.
So then they're going to have... But the point is...
Well, just to make clear, you relied positively on what was said by the Divisional Court at paragraph 57. I'm just questioning what was the foundation for them making that statement, which at first blush seems to be contrary to what one would expect to be the position. Is there anything further you wanted to say?
Well, other than on a parole board review, you are actually looking at release into the community rather than the length of the tariff. I mean,
but I think you just told us that the point of the review of the minimum term is to bring that whole process forward.
Yes, it is, but it isn't. My lord, it's as simple as this. If it's a good point, I don't know, but if the family are being told this person is having a parole review, if it's successful, he will be in the community, that's likely to have a bigger impact than he's having a review which may reduce his tariff, which may mean he's looked at by the parole board a bit earlier.
Yes, right, thank you.
I mean, it's the difference between complete liberty and one step in the process.
Yes, anyway, you were giving us a list of the factors that you say, I think, narrowed the margin of appreciation.
Yes. And then, it's that the sentence, if the sentence requires and anticipates a review, then that's as a matter of law flowing from the nature of the sentence. And fifthly, there was also, you have the point, a failure to consider whether some less draconian measures could have solved the problem. My lord, I think I've made my submissions on that.
Yes.
And we say that apart from the point that the reduction of reviews, of any reduction of reviews, will inevitably reduce the quantum of distress generally, there's nothing about the reviews of someone who's sentenced after 18 that's particularly distressing. I mean, therefore, there's no relation between this particular choice and the reduction of stress. It is simply that the less reviews there are, the less totality of distress there'll be. There's nothing particularly distressing, in our respectful submission, about someone who is 18 years and 3 months having a review as opposed to someone who's 17 years and 9 months. And in that sense, the choice of those who are disentitled is not rationally related to the reduction of distress.
Right.
My Lord, that's that point. Then, my Lord, on Article 5, it is quite a straightforward point.
Right, so we're moving on to your next submission, Article 5, yes.
On Article 5, and we respectfully adopt the reasoning of the Divisional Court, paragraphs 59 to 61, removing any possibility of exercising a more reliable judgment so as to reduce the minimum term will inevitably result in a number of offenders serving longer than they lawfully should.
But why do you say longer than they should? If the point of a judge giving a sentence which establishes a minimum term, one might say, well, that's the term they should serve.
Yes, well, if it's an essential part of the rationale that those who make exceptional progress should have a reduction, and that is our submission, then clearly removing the possibility to win a reduction of the minimum term through exceptional progress does mean they serve longer than they should in accordance with the rationale of the sentence. The rationale of the sentence contemplates the reduction of the tariff if you make exceptional progress. So
this seems to go back to your point, I think, on, is it paragraph 11 of Smith?
Yes.
That there's some underlying continuing inherent nature of the sentence, which even though which governs the position, even though a judge has gone through a whole sentencing exercise and imposed a minimum term. Somehow you say that because we apply the label detention at Her Majesty's pleasure to this form of sentence, that means that even though Parliament has laid down elaborate provisions to set out minimum terms imposed by a judge, nonetheless, the underlying inherent nature of the offence means that there still has to be continuing review, which can mean that someone is released even though they haven't served the minimum term. I think that's what it comes down to.
Well, my Lord, that's it, that is implicit in the sentence. Yeah. That if you make exceptional progress, your tariff will be reduced. That's the submission, my Lord.
Yes.
And my Lord, that the only other point we make is that
not so much in the sentence, but in the time served.
So yes, the minimum term, because the minimum term is then refixed. Yeah. In accordance with, I mean, that is important, that the statute provides that the minimum term will be recalculated as a result of this, and a new minimum term will be fixed, and that's 27B. Sorry, 27B. The reduced term becomes the term, so it's an opportunity to have the term refixed.
Can I just ask you this? Given that the setting the period of actual detention where you have detention at Her Majesty's pleasure is an exercise, as I would understand it, of the prerogative, because the court has essentially put the person into the care of the monarch, who then has to exercise their own judgment. Might it not be said, and I want you to deal with this, that when Parliament intervenes in 2000 with Section 82A, which both gives the role to a judge to set the minimum term, but also Section 82A subsection 2 says that an order should be made, unless subsection 4 applies, to apply the 1997 Act early release provisions. Might it not be said that Parliament has occupied the territory which formerly was occupied by the prerogative, and that in itself indicates that there is no prerogative left to be invoked at that stage?
Well, my Lord, prior to...
so far as the sentence is concerned, you're left with the prerogative of mercy, which hasn't been touched, but I was focusing on the inherent nature of the detention, which you've been focusing on, paragraph 11 in Smith.
Yes. Well, we say that the inherent nature of the sentence calls for that review. But, my Lord, what we say about the prerogative of mercy is this was the mechanism by which...
Sorry, just to be clear, I wasn't asking you about the prerogative of mercy. By all means, make a point on it if you want to. I was asking you about your submission that it's inherent in the nature of detention at Her Majesty's pleasure that there should be continuing review throughout. And I was asking you to address a possible argument that that is a feature of the prerogative nature of the sentence which is imposed of detention at Her Majesty's pleasure. But once we move past the statutory reforms in 2000, that structure has been replaced by statutory provision, which says what a judge shall do, and that the early release provisions will apply, sentencing provisions in the 1997 Act will apply. And I was asking you, might it not be said that the fact that Parliament has intervened to regulate that particular aspect of the form of detention which was previously regulated by the prerogative means that the prerogative has been displaced and one's left with the statutory regime so far as the sentence is concerned?
My Lord, all I can say is, respectfully say, is one has to attribute some significance to Parliament's repeated reenactment of the statute in those terms, rather than saying, well, it's now effectively no different from life imprisonment. And that's the reason why I say that Parliament is still post Smith, they continue to reenact detention during Her Majesty's pleasure in 2020, knowing what Smith has said about the inherent nature of the sentence, and knowing how that has been interpreted in practice by the executive as requiring a review.
Well,
So
prior to the 30th of November 2000, I'd understood you earlier on to be agreeing that the Secretary of State wasn't exercising the prerogative.
No,
it was just
it was a statutory.
it was just on a statutory basis,
Yes.
exercising a discretion as to
Yes.
how long a person should be detained for. There are lots of sentences which are imposed where Parliament has set out what should be imposed. As I understand it, the prerogative of mercy still applies.
Yes.
Insofar as compassionate grounds can be used,
yes.
or there can be a whole series of grounds upon which it can be used. What I have some difficulty in seeing is how this operated after the 30th of November 2020 at all.
Yes.
Because the judge set a minimum term and imposed a detention of at His Majesty's pleasure. And so I was just wondering how that gives rise to an obligation to review. At the moment, I don't see it.
Well, my Lord, it can only be because
the word,
because of the concept,
because of the label.
Detention during pleasure is, as it were, overpowers or qualifies that the judge has set fix your tariff. That's it, and we do, and I won't labour the point anymore, but we do attach great significance to the fact that Parliament has repeatedly reenacted that as the sentence, not life sentence, but detention during Her Majesty's pleasure, an indeterminate pen. But my Lord is correct that the discretion to, it was described by Lord Steyn as a discretion to, and Lord Wolfe in the Court of Appeal, discretion to continue detention during Her Majesty's pleasure, that was the foundation of a position prior to 2000 rather than the prerogative of mercy, i.e. he had to, the Secretary of State had to decide from time to time how long the person should be detained for.
So you've referred to two judgments there, one by Lord Steyn and one by Lord Wolfe. Can you just give us the
Yes.
I wasn't quite sure what you're referring to.
Lord Steyn, it says it's... yes, I'll give you my...
Is this in Smith?
No, it's in Venables.
Oh, in Venables.
But Lord Steyn says it's a power to continue. It's a power to continue detention rather than to end detention. And Lord Wolfe, and he's echoing what Lord Wolfe says to the like effect.
In the Court of Appeal in Venables?
Yeah, Court of Appeal in Venables, Lord Wolfe says, after all, detention during Her Majesty's pleasure is about the power of the Secretary of State to continue detention rather than to stop, to end detention. And Lord Steyn says the same thing, detention during Her Majesty's pleasure is a power to continue detention rather than...
All right.
To bring it
do you have the page references? If you don't take up time on it, present.
It will take me 1 second.
All
I
right.
think, I hope it will. 66, hang on. So, it's Lord Steyn.
1534 at...
Yeah, 1534A, yeah, absolutely, yes. And then Lord Wolfe in the Court of Appeal says the same thing. It's at 426C. The discretion is to bring custody to...
1426?
1438. 1438, page 426 at the top, 1438 at the bottom. The distinction is no more than that which flows from the fact that in the case of one sentence, the discretion is to bring custody and end. The other is the discretion to continue custody. And so, as my Lord, my Lady, just very shortly to end on this, we say that we echo what Lord Bingham says in Smith at 12. It would, in many cases, subvert the object of this unique sentence if the duty of continuing review were held to terminate when the child or young person legally comes of age. That's at 1255A. And we say what renders the change incompatible with Article 5 is if detention pursuant to the sentence becomes incompatible with the rationale of the sentence. And that is the situation created by the removal of the review pursuant to section 27A11. That's our point on Article 5. And we also say that it was not foreseeable from the start of the sentence that the review anticipated, in accordance with existing practice and the rationale of the sentence, would be removed. We rely there on my Lord Stevens in Morgan and Ministry of Justice at page 997, paragraph 121, that foreseeability is relevant to the test of arbitrariness under Article 5. So,
sorry, the Morgan reference was page 997.
The Morgan reference is to my Lord Stevens' judgment.
Yes.
In page 997, paragraph 121.
Oh, thank you.
So, was it foreseeable? Then I better just deal with Article 7, my Lords, my Lady, 2, because we say if one looks at my Lord Stevens' judgment in Morgan and the Ministry of Justice, we've referred to that at paragraph 98 of our case, but the key passage is at page 980, at page 980, paragraph 104, where my Lord draws the distinction. So it's page 993 at the bottom. So page 993 at the bottom, where my Lord Stevens says, two propositions follow from the above. First, where a measure relates to the execution or enforcement of a penalty, it does not fall within the concept of law in Article 7.1. The requirements of foreseeability does not apply. So it does apply with Article 5, but not with Article 7. Second, wherever a measure relates to a change in the penalty imposed, and as such falls within Article 7.1 of the ECHR, any such change falls within the concept of the law within Article 7.1 and is subject to the qualitative requirement that follows, including foreseeability. And what our simple submission is that effectively subsection 11 does amend the sentence.
Sorry, section 11, subsection 11 of
Subsection
27A.
Of 27A. So 27A, subsection 11, by effectively saying there will be no review for those sentenced after the age of 18, has taken it away a right. And that is consistent with, so wherever a measure relates, so this is Morgan 104, wherever it relates to a change in the penalty. Now, at paragraph 119, this is at page 106, the respondent, so this is paragraph 119, page 106, the respondent says that, I quote, Parliament has expressly and therefore deliberately amended DHMP sentences in a single but important way relevant to this appeal, i.e. they've amended the sentence. That express contention is effectively a concession as to the nature of the statutory exercise involved in subsection 11. It strongly supports the appellant's alternative point, paragraphs 91 to 92 of the case, page 56, that the effect of section 27A is to retrospectively amend the sentence in such a way as to make it a harsher sentence than it was originally. It's amended the sentence. How's it amended it? To take away a right that was thought to exist and that was being exercised right up until the time of the policy change.
So we're now on to Article 7, are we?
Yes, my lord, yeah. So if indeed the appellant's sentence has been amended by Parliament to his detriment in 2022, many years after it was imposed in 2015, then that would give rise to a retrospective harshening of his original penalty, contrary to Article 7. And we deal with this point in our case at paragraphs 89 to 101. That's pages 55 to 59 of the case. And, my lords, my lady, there are just two cases that so we say, they actually say themselves, the sentence has been amended. And the test which my Lord Stevens formulated, well, based on authority, obviously, in Morgan is, does it involve an amendment of the sentence? And they're saying, yes, it does involve amendment of the sentence.
Sorry, where do they say that?
My Lord, so they say it at paragraph 119, page 106. They say, Parliament, this is, I quote, Parliament has expressly and therefore deliberately amended DHMP sentences in a single but important way relevant to this appeal. It's amended.
They seem to distinguish between penalty, because at paragraph 100 they talk about it not altering the penalty originally imposed, and the overall DHMP sentence regime.
Well,
I'm not sure that they are conceding a change to the penalty. But
well, it's important to their argument that because otherwise one has the Article 5 point that the sentence it carries with it an entitlement to continuous review. They say, no, it's been amended in an important but way relevant to this appeal. But let me put it this way, that what I'm respectfully submitting is, when sentenced, this appellant was sentenced to a relevant term, a minimum term, understood to be reducible by application for a reduction, which, if successful, would lead to a refixing of what happened was you then got a refixed penalty. And if you got 2 years off, his sentence would have been refixed at 13 years. So it was a reducible penalty. And in the case of Kupinski, which we've analysed in our case at paragraphs 90 to 92, the European Court expressly recognised, this is at pages 1767 onwards, that the transformation of a sentence from a reducible term to an irreducible term does involve a retrospective harshening of a penalty. And that's at page 1780 of at 1780, tab 76, 1780. So one sees there, paragraph 51, as the court found, the applicant's sentence imposed as a result of conversion is irreducible under current Ukrainian law. Thus, the principal difference between the present case and previous cases, which I mentioned, is that the latter concern the terms of granting the parole, while in the former there is an issue of unavailability of parole as a matter of law. Well, the court also observed that, as can be seen from the relevant provisions, it does differentiate between reducible and irreducible life sentences. In the applicant's case, the domestic courts in Hungary had explicitly decided to impose on him a reducible life sentence and not an irreducible one. So originally he's sentenced to a reducible life sentence, but when it's converted in Ukraine, it becomes an irreducible term. And then at paragraph 56, page 1781, the court therefore concludes that by converting the applicant's original reducible life sentence to the irreducible life sentence under Ukrainian law, the domestic courts in the particular circumstance of the present case went beyond the mere measures of enforcement and changed the scope of the applicant's penalty. Article 7 is therefore applicable in the present case. So we say, to the extent that they changed the penalty, they amended the penalty, from there being a reducible minimum term in accordance with the policy, the practice, and indeed numerous judicial exercises which were cited by Lord Justice Davis, judges actually reducing minimum terms and minimum terms then being substituted. So that was the reducible minimum term in accordance with judicial practice and in accordance with the policy. They were being reduced. That was the position in 2015. And it happened in a number of cases, including people sentenced over 18, which are referred to by Lord Davis, Justice Davis. It becomes an irreducible because there's no access to the mechanism for reduction.
Well, it's not irreducible because it's a life sentence that is reducible at the end of the minimum term rather than at the halfway point.
That depends on the level of abstraction at which one looks at it. If you say there's two parts of the sentence, when the Court of Appeal authority, that the minimum term is a sentence, it's a sentence which is appealable. It's a discrete sentence.
Well, it's part of the sentence.
Well, okay, but it's just as much. I mean, if you can
appeal the level of.
You can appeal the minimum term because it is a sentence that's appealable. You can reduce the minimum term because it's a. Sorry, I don't mean to be aggressive, but that's why I sound. You can reduce the minimum term because it's a minimum term that's reducible.
Yes.
And therefore this flight into abstraction and saying, oh, well, he's still got a life sentence. No, he's got a minimum term. The judge has pronounced it, and it's reducible. And all of a sudden, it becomes irreducible, the minimum term. And it's no good saying, oh, well, it's all in the context of a life sentence. His minimum term, which is just as much to him experienced as and lived as a sentence within a sentence, an appealable sentence, has gone from 15 years, but it's reducible, to 15 years, but it's irreducible. And we say that is Article 7.1, retrospective harshening of a penalty, in accordance with the Kopinski test, in accordance with my Lord Stephen's formulation in Morgan, and their own concession that the sentence has been amended. One was highlighted. The final one is Del Rio Prada. I think it's sort of brain of Britain. Who can understand that case? But I'm going to do my best.
Before doing that, I see the force in the argument you're making, but I'd like to take you to another proposition, and that is that, well, to inquire from you whether the reducible element is based upon progress after sentence is made.
Well, according to Lord Bingham, it's based on progress after exceptional progress,
yeah.
A discovery of new facts which cast light on the level of penalty that was appropriate, and compassionate. That's Lord Bingham's three, which are transferred into the policy which we have at the October the 18th policy, page 5. It's 581. That's.
Yeah. Well, if new facts are found, well, presumably there could be an appeal out of time.
Yes, I appreciate
so, but insofar as it is taking into account progress since the sentence was imposed, isn't that really an assessment of a different nature? It's akin in some ways to remission. So, good behaviour in prison used to earn you remission. That reduced your sentence. You got out of prison earlier. This one, it is excellent progress in prison, in detention, means that you have you get a chance of getting out on parole at an earlier stage. So, isn't that the execution of the penalty? Insofar as remission would be the execution of the penalty, quite clearly remission would be. And isn't this akin to that?
Well, my respectful submission is, one, it minimises the fact that your sentence is actually reordered, as it were. What happened in the years 2005 to 2022 was that the judge would hold a hearing. If he took the view that you satisfied one of those three criteria, he would then refix the tariff at a reduced minimum term to reduce. So it was a resentencing, effectively, in accordance with those things. Yes, I mean, it's at paragraph 12 of Lord Bingham 168. He sets out the factors which include progress and progress and a relook at the original offence in the light of further developments, further revelations, and that's the point. Yeah. Yes. I'm sorry. Yes. The language he uses is reassessing what punishment he deserves, reassessing what punishment he deserves. And that was the exercise, because what happened was the policy was to reassess what the punishment he deserves in the light of the three factors identified by Lord Bingham and encapsulated in the October the 2018 policy statement, which is page 581. So those were the three factors. So he talked about reassessing what punishment was deserved.
I think you just said that under the policy which used to apply, the judge would refix the minimum term, but that's not accurate, is it? I mean, the judge has no power to refix the minimum term, which was fixed by the trial judge.
Well, that's what did.
I would have thought, but tell me if I'm wrong, that what is happening, or was happening under the policy as it applied down to the introduction of section 27A, was that the matter would be referred to a High Court judge to give advice to the Secretary of State, essentially as to whether there should be early release using the prerogative of mercy.
Well, no. What would happen is that the minimum term would then be, as it were, altered. So if it had been 15 years, it'd be altered to 13 years.
But not by the judge.
Well,
surely. It could only be by the Secretary of State as an act of clemency on behalf of the sovereign.
After notification by the judge that that was the appropriate step, yes. The Secretary of State followed that. He was bound by that.
Yes, but what is occurring is the Secretary of State, as the responsible Minister for Justice, is exercising the royal prerogative of clemency, isn't it? Well, it's not the judge saying, oh, by the way, that sentence I imposed, I'm now going to set it aside and I'm going to impose a different sentence.
Well, it usually wasn't the same judge. I mean,
or a judge.
Yes. Sat on those. Well, my lord, I think there are some examples in the which in the bundle of what actually of what actually happened, and Lord Justice Davis refers to them.
Well,
yes, sorry.
There simply is no statutory power to do that. The statutory power to set a minimum sentence has been exercised already.
Yes, well...
the judge that's done that is functus officio. You can appeal, but we're not talking about appeals. Indeed, I thought in answers you gave this morning, you were accepting that the nature of the exercise that happened under the previous policy after 2000 was Secretary of State seeking advice from a High Court judge as to whether to exercise the prerogative of mercy. I thought you had accepted that.
He considered himself bound by the decision. The effect of it was that a new term was fixed. A new term. I accept the Secretary of State, as it were, was the medium, but right. the decision maker was the judge, and he held.
Sorry, what is this? Are you just deriving this from Lord Bingham's judgment in Smith?
No, I'm deriving it from what actually happened.
But where? It just doesn't sound.
What?
Where do we have anything that supports this?
Well, yeah, we've got the actual cases where they did it. Lord, sorry. Page 1577. So, I mean, I appreciate that this court can consider whether. But you can see 1577. Yes. It's Justice Johnson. The case of Essel test to be so you see, and then I recommend that page 1581 applicant is reduced by 18 months in the light of exceptional progress. The applicant will not be released now, remain in custody at least until he has served the minimum.
Well, paragraph 10 says the review is carried out in practice by a judge who may recommend that the tariff be reduced. And then the Lord Chancellor has agreed to honour any recommended reduction.
And then, my lady, you see the criteria for reduction.
Yeah.
And then, and then one sees, I do, however, consider the made exceptional progress. Well, I mean, that was the exercise that was carried out, and effectively, the recommendation was always accepted. So the minimum term is reduced. And then it's refixed in their records as a new minimum term. And so that's the exercise which gives rise to the legitimate expectation. It's been carried out in case after case after 2005. And but it does reflect the fact that by a judicial consideration, the term can be refixed. My Lord, I mean, I could get into the abstruse question of prerogative of mercy, but I don't accept that prerogative of mercy is, I mean, it's law. If the Home Secretary reprieved someone who'd become mentally disordered, that was described as ex debito justitiae, not ex mandato regis. It was there is law in governing the way in which you exercise the prerogative of mercy. Same is true of Bentley, where you see the penalty, the recommendation that the penalty should be reduced posthumously from death to life imprisonment for reasons of law. And Neville Lewis, the Privy Council decision, saying that the prerogative of mercy is reviewable and governed by principles of due process itself. So this isn't some gratuitous exercise. It can be essential to the functioning of a legal system that the prerogative of mercy be exercised. And we've given the Ford and Wainwright case but what we say is that this was a reducible penalty in accordance with a legal procedure. And then that leads into Del Rio Prada, where, I know that my Lord Stevens analysed it in the case of Morgan, but we've analysed it in our case at paragraphs 93 to 100. The case is at 1610 onwards. We've set out the test in Del Rio Prada in our case at pages 56 to 58. Firstly, they say one must look at the penalty having regard to domestic law as a whole, the way in which the penalty was approached at the relevant time. That's Del Rio Prada at paragraph 96, page 1643. And at paragraph 98, page 1644, the court goes on to stress the importance of the case law and practice regarding the interpretation of the relevant provisions of the Criminal Code of 1973. And this was about, of course, remission, how much remission you could get. But nonetheless, it was held to be a violation of Article 7 to, as it were, shift the goalposts. At paragraph 99 to 100, the court looked at the practice, that's at pages 1644 to 1645, of the Spanish prison and judicial authorities in respect of remission of sentence and the calculation of the remissions of sentence to which it applied. The court went on to stress that this gave rise to a legitimate expectation that the penalty to which remission would apply would be the 30-year maximum. And then at paragraphs, I just draw attention to paragraphs 104 and 109, but at paragraphs 111, so yes, the original sentence was 30 years to which remission applied. We see that at paragraph 103. And then at paragraph 109, what changed was that sentence imposed became one to which no such remission would be applied. So there's a change from what was the practice and the understanding to a new understanding because of a change in a ruling of the court, something called the Parrott Doctrine. And at paragraph 111, the court inquired as to whether the change in the law was foreseeable and concluded that it was not. They concluded at paragraph 117, this is at page 1650, that departure from the case law had the effect of modifying the scope of the penalty imposed to the applicant's detriment. Well, that's exactly what we say has happened. The scope of the penalty has been modified to the applicant's detriment.
But this was a statutory provision that allowed you remission
yes,
in a 30-year sentence.
I accept that. Well, I think in European court terms, it doesn't matter whether it's statute or what matters is whether it's a practice you're entitled to rely on. And applying that approach to the appellant's sentence.
Well, before you go on, is that a convenient moment? It seems unlikely you're going to finish this.
Yes, my lord, I've got 15 minutes more, I think, tomorrow.
You have.
Yes, yes, my lord.
It doesn't strike me that this is an authority that we should be rushing through, so... No, my lord, and I think I'm really very nearing the end, you know. All right, so is that a convenient moment?
My lord, it is.
Yes, very good. So we will adjourn now and resume at 10:30 tomorrow morning, please.